Hey, hey, hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now state the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. My name is Amy Blake, along with Justice Maureen Walsh and Justice Rachel Hershfang. We are your panel for the 4 cases that are on the list this morning. Most of you have been here before, but just to go over a few housekeeping rules. Each side is permitted 15 minutes of argument. There is no rebuttal. I can promise you that we have read all of your materials, so you should move straight to your arguments. There are a couple of matters on the list today that are partially impounded, so when we get to those, I will remind counsel that they are not to use the parties' names. With that said, I believe the first case we're hearing today is Commonwealth versus Paul Collins, docket number 22P0438. Counsel, good morning.
Good morning, Your Honors. As pleased to court, my name is Robert O'Mara. I'm representing Paul Collins on an appeal. We're here to appeal the denial of his motion for a new trial, in which we argued that Mr. Collins received ineffective assistance of counsel for her failure to adequately research the corroboration requirements of 277-63.
Let me interrupt for a moment.
Oh, sure.
What should have counsel done other than research? What advice and what actions were ineffective that caused Mr. Collins to plea to these cases?
In her affidavit that accompanied our motion for new trial, she stated that she advised Mr. Collins that he had poor chances at trial, and she pointed to a statement in the police, a statement, unsuppressed statement in the police interview report. Also, she pointed to the fact that he worked at the Arlington Boys Club, and she also pointed to the fact that there were 4 complainants that would have testified at trial. And in my brief, I argued Commonwealth versus Helfand. I would think that anybody who read Helfand would not have advised the client as such, since the fact that he worked at the Boys Club, the fact that there were 4 other complainants, and I'll argue later that that statement that he made to the police that was unsuppressed doesn't provide corroboration.
So at the time, there was no case about the particular meaning once such a significant period of time had lapsed about what corroboration means, correct?
Well, there was Helfand. That was a different statute. I understand that. But in White, they point to Helfand, and they said that as far as Helfand was concerned, it was a good case to interpret those corroboration requirements of 277-63.
So my question first is looking forward, what counsel should have said, which, I mean, I looked at her affidavit, and she didn't tell Mr. Collins whether to plea or not. She gave him the options, like many attorneys do. But now, taking a look of what we know now, it seems as if, given the facts of this case, her advice was correct, wasn't it?
Well, again, I'm going to probably mention Helfand several times, but I think that if she read Helfand, she would have understood that corroboration was lacking in Mr. Collins' case.
What about his statement?
I'm sorry, Your Honor.
What about his statement to the police?
Well, that's interesting. So the statement to the police was it was an unsolicited statement, and he said, I might have been over-friendly to those kids, but I never raped anybody. And if you compare that statement to the statement in White, where, Bruno, where the professor, in response to a statement by one of the victim's friends, the friend said, excuse my language, you really fucked up last night. The defendant, Roger, stated, I know, and it won't happen again. It was a direct reply to a statement, to a question. And we don't have that in the Collins case.
Well,
I mean,
do you think that makes a difference? In other words, because there was a back and forth conversation, if in this case, and I understand it isn't, but if he said, yeah, I'm guilty of all these counts, it wouldn't really matter that it was an unsolicited question or conversation. The corroboration is in the statement itself. So when I look at the statement in Bono and I look at the statement here, neither one of them absolutely admits, but there are circumstances that I think meet the corroboration requirement because of the time passage. But tell me where I'm wrong in that analysis.
I would argue that in our case that, I think if you look through the cases, if you look through Hershfang, White, and Bono, the common thread is that the corroboration has to relate to the specific criminal act. Mr. Collins' statement, I would argue, does not really relate to a specific fact.
Well, but in addition to I didn't rape anybody, didn't he also say I did not force myself on anybody? And granted, the Commonwealth didn't proceed with rape of a child with force on that theory, but I did not force myself on anybody seems to come close to the Buono statement.
Well, I mean, I argued in my brief that that was more of a denial than an admission. And again, I'll go back to Buono. You know, it was so specific, and I can understand how that could possibly be corroboration. It was so specific. The victim's friend was referring to an incident that happened the night before where the victim told his friend, I was with Roger and this happened, blah, blah, blah. So it was very specific to the night before, to the sexual act the night before. In Collins' case, he said it wasn't related to a specific act. I might have been over-friendly to those kids, but I never raped anyone. So, I mean, certainly, I can understand, I mean, in the denial of my motion, you know, the Superior Court said, you know, the grand jury could have interpreted that as you just have interpreted it. But again, reading through the cases, reading through those three cases, and, you know, comparing it to, especially to the statement in Buono, I think Mr. Collins' statement was too vague, too nonspecific to provide corroboration.
We see lots of cases where someone's looking to withdraw their plea for a variety of reasons, and ultimately we end up having a conversation about disposition. So your client was facing life sentences, is that right, on the rape of a child with force?
Yes, and, you know, and
Potentially consecutively.
and it could have been, yes, and it could have been consecutive sentences.
He got a deal here, didn't he?
Yes. However, Your Honor, I think what the mistake was that counsel failed to inform him of the range of outcomes that could come from a trial or a plea. She didn't do that. And I think if you read any of the cases, it says, you know, obviously the defendant makes his own choice. So I don't know how he could have made an informed choice if he wasn't informed about the corroboration requirements or a possible defense due to lack of corroboration. That wasn't present here. So he wasn't able to make a proper choice.
I think, I won't speak for my colleagues, but the trouble I'm having, at least with that argument, is that there appears to be corroboration in the record. And although perhaps after White was decided and before Bono was decided, there might have been a needle that you could thread about whether the corroboration was adequate, it seems to me at least that the SJC has conclusively answered that question in the affirmative following the Buono decision.
Well, when I read Buono, I didn't see a huge change in the law. What I did see was that they held that statement that the defendant made was corroboration. I mean, if you read Buono, the rule, I don't think the rule has changed that the corroboration has to be geared towards the specific criminal act.
I agree with you about that, but I do think the way the law was developed in that case, at least in my reading, is it put down one pin about what is adequate corroboration. And the pin is mighty close to the facts of this case. It was a statement by the defendant with some vagueness. I mean, certainly it's not a confession. No one is arguing either your client's statements or the statements in that case amounted to a confession. But there seems to be an acknowledgement of feelings of guilt or remorse. And the Supreme Judicial Court has told us that's adequate corroboration.
Well, if I could bring up Helfand, if you look at the corroboration of Helfand, the doctor admitted that he injected the victim. The blood analysis showed Valium in the bloodstream, and there was also the puncture mark from the injection. I mean, that's a lot of corroboration. I mean, then if you look at my case, so the corroboration so you put it to a corroboration where he said, I might have been over-friendly. I mean, I think there's a huge difference between those two statements those two pieces of evidence to form corroboration.
I don't disagree, but I also don't read Helfand to say this is the quantum of corroboration that is required. I read Helfand to say this quantum of corroboration is adequate, but not to say that anything less would be inadequate. And then Buono comes along and says, okay, this is enough, actually. And that's where I think you run into trouble, because your this is pretty similar to that this, to say something completely incoherent.
Yeah, I mean, I agree with you that, I mean, it seems to me that, the argument now is, how close is Mr. Collins' statement to the statement in Buono? And for the reasons I just mentioned, I don't think they're anywhere near the same. I think, and again, I think the standard hasn't changed through those three cases. I think in Helfand it says, they mentioned the material particular, which is some testimonial fact. It's probative on an element. Then White said pretty much the same thing, but probative on the specific crime. And I don't think that has changed in Buono.
Can I interrupt for a moment? If we're to accept that you raise an argument about ineffective assistance of counsel, talk for a moment, if you will, about the second prong of Safarian. And I'm not sure I think Justice Blake mentioned earlier, how is your client deprived of an otherwise available substantial ground of defense, even if we were to accept that the actions and advice of counsel were ineffective?
Well, if you read, I'm sure you have, if you read Mr. Collins' affidavit, he states that had he been informed of the corroboration requirement under existing law, at then existing law of 277-63, he wouldn't have chosen to plea. And I think that you read...
But that's not enough, right? Case law...
Well, I understand that's
right,
self-serving,
so.
but then if you read Attorney Reagan's affidavit, she states that she would have advised him not to plea if she had been informed under, again, Helfand. I think the ineffectiveness is that he wasn't given wasn't informed on the full range of his options. And I think that if he had chosen to go to trial, the timing of things was, White came out in 2016. he pled in 2015. It's likely that, so the outcome would have been an outcome that, you know, you would have looked at either Helfand or 2016. If it took that long to get to trial, he would have had White, and I think he would have succeeded. He had a fairly good chance of succeeding under White. So he was deprived of his chance. He was deprived of information that could have informed him of a corroboration, lack of corroboration defense.
Your time is coming to an end. I don't see any other questions from the panel. We're happy to take the rest of your arguments on your brief.
Thank you, Your Honor.
Thank you, counsel. Attorney Rao?
Good morning, Your Honors. May it please the Court, Assistant District Attorney Ryan Raw from Middlesex on behalf of the Commonwealth. I just want to start my argument first by clarifying Bueno itself, because I think that counsel may have misstated the relevant facts of the statement. There's actually two statements in Bueno. And the statement he referenced of "I effed up, it won't happen again" is the day after an incident in Italy. So it's an uncharged, no jurisdiction related statement. The actual statement in Bueno that was considered sufficient corroboration is many months later, in spring of 1981, after the victim in that case had been abused about 4 to 6 times during the time period. A friend says, "I spoke to the defendant and he said, I have my issues, it won't happen again." So the reason I want to start there is because the statement is not set to a certain time frame that was actually corroborative. It isn't even set to a specific incident. And the incident reasonably could have been, as the defense argued, a reference to Italy itself, because he had already acknowledged the conduct and he was getting in trouble in part because of the conduct from Italy. So I wanted to start with that because the contrast of Bueno's statement to the statement in this case is clear. The statement in this case is much more corroborative than the statement in Bueno. It references a particular time frame. And why I say that is I have attached the entirety of the transcript from the unsuppressed section of the interrogation. And it details, the police provided him information about all of the allegations before he admitted that he was over-friendly with a couple of boys at the swim club and that he didn't force himself on anyone. And there's also another statement that the motion judge relies upon, and that's at Supplemental Record Appendix page 101. That's the only one that happened, is what he says in response to an allegation about the forcible rape charge actually involved at the house, involving one of the 2 brothers who are the victims on some of the counts. So I start there because the question in this case is whether counsel was ineffective for not researching the corroborative evidence requirement under Chapter 277, Section 63. Also raised questions about whether they would have pursued a motion to dismiss and whether it would have advised the defendant of defense and proceeded to trial. So first of all, an ordinary fallible attorney wouldn't have determined this issue. And I say that because...
So let me stop you there for a moment. We didn't have White or Bueno at the time, right?
Correct.
So I think we only had, according to Brother Counsel, Helfand.
Correct.
And that would not put defense attorney on notice as to the corroboration issue, according to you. Tell me why.
Okay, so I would say first that the statute is written in a completely different way. So the statute in Helfand says, unless the testimony is corroborated by a material particular. And the language in Chapter 277, Section 63 says independent evidence that corroborates the victim's allegation. It doesn't reference the material particular language. It's actually unique. There's no other statute that I'm aware of that uses that language. And at the time in which counsel would have been researching what corroboration meant, you had Commonwealth versus Green, which talks about the level of corroboration of a defendant's statement. You have Commonwealth versus Jacobs, which talks about the level of corroboration needed for an immunized witness's testimony. So all of the relevant case law regarding everything else but Helfand would have suggested that the corroboration was more than enough, actually, under the statute. But you know, counsel wasn't required to be clairvoyant. And I cited the Smith case, the Barron case, and the Norman case. You know, missing a novel defense in which the SJC noted in White in 2016 was a question of first impression, and they obviously took from Hershfang. I do not think that that was a foregone conclusion or an understanding before, because as I said, all of the case law before that point as to the definition of corroborating did not suggest that.
What do we have in the record about the actual plea deal and the sentence he got versus what he could have faced and what the Commonwealth was asking for? Was this an agreed upon?
It was a lobbied case. It was a slightly disparate plea. The defense attorney was asking for less, if I don't recall the exact numbers, but this sentence is actually in line with the Commonwealth's recommendation for a plea before trial. But what you do have in the record as well is evidence from trial counsel herself that says this was a very strong case. He was facing consecutive sentences. These are 4 separate incidents across 5 counts, all of which were very compelling from her perspective. There was no apparent motive. The defendant in all of those cases abused his authority as the swim instructor and sort of head of the Arlington Boys Club pool area to get close to kids and engage in this deplorable behavior. So in that sense, the judge, the motion judge, who was also the plea judge, noted the potential penalties he would have faced had he gone to trial. And even trial counsel acknowledged that and advised him, and that is, so he was facing significant penalties if he didn't take the plea that was offered. And just going back to briefly on ineffective assistance, the exact statement that Attorney Regan made was, I believe that multiple complainants, evidence of the defendant's employment at the Arlington Boys Club, and the unsuppressed portion of Mr. Collins' statement met the corroboration requirements. That's correct. That's bueno. So the fact that the timeline of this is interesting and important because perhaps that statement under Just White would have been an open question. But by Bueno's point, by the time you get to Bueno at this point, which is when we actually had the hearing, Bueno had already been decided, it's clear that her statement was correct. So it can't be ineffective for advising someone that there's sufficient corroboration when there is, in fact, sufficient corroboration. But I think the crucial and the most important and the straightforward answer here is even if this court found that counsel was ineffective for failing to research this issue, try to bring a novel defense, which obviously I don't agree with, they can't meet the second prong of Safarian, which is to show there was a substantial available ground of defense that he was deprived of. And as trial counsel noted, the facts of this case were very strong, no motive, 4 victims. What this trial would have been about, one has to question, is a technical defense about jurisdiction in which we're trying to interpret the defendant's statements. And as we know from Bueno, any ambiguity in that statement goes to the jury. So the defendant is in a position where he's being offered this sentence as a plea or faces the prospect of consecutive sentences. And looking at that, he has to basically focus the jury's attention to the statements he made throughout the interrogation about this behavior, which starts as a complete denial and proceeds to these statements and includes a lot of corroboration that wasn't in Bueno about working there at the same time frame, remembering 2 of the boys from that time frame, remember being at their house, remember it. So I understand that that's not sufficient corroboration of the actual crime. It's still sufficient, it's more corroboration as to time, as to place, as to the lack of ambiguity than what was in Bueno.
Is the corroboration required for the indecent A and B?
Yes, it's for the indecent A and B's.
What about the open and gross?
Not for the open and gross, that's correct. Which I don't think was an issue from the perspective of both the defendant and the Commonwealth in this case, given the lesser nature of that charge. But I just wanted to finish off by saying that finally his statement about describing the rape as he says, I didn't rape anyone, I didn't force myself on anyone. There are numerous references in the records that make it clear what he's getting at with that statement. So as I argued in my brief, but I also just wanted to give the page numbers, I mean, just before the statement on page 217 of the supplemental record appendix, in 217, he explains that his understanding of rape is that it has to be forced, physically forced. That's what he's basically saying on page 217. And then again, he says it on page 110 earlier in the interview that he never forcibly raped someone. So where the theory is constructive force based on his relationship to the parties, and quite frankly, the fact that the facts support that the child was asleep when this oral sex incident occurred, and he woke up to it. At least those are the basic facts of what happened. I would also suggest it equally corroborates that, with the additional statement that the motion judge relied upon where he said this is the only one that happened. So if there are no further questions, I would just yield the rest of my time and rest of my brief.
I don't see any. We will take the rest on the brief. Counsel, thank you both. Very helpful arguments. The case will be deemed submitted. The next case is a DCF case, docket number 22P0909. I know we have 5 attorneys that will be coming forward. Just a reminder not to use anybody's names. Mother, father, child, numbers, that's all. And as you get set up, I want to just make sure I understand. Mother is 7.5 minutes. Child 1 and 3 is 7.5 minutes. DCF is 7 minutes. Child 2 is 4 minutes, and child 5 is 4 minutes. Are those the correct times?
Yes, Your
All
Honor.
right, so I'm guessing that we're going to hear from Mother's Counsel first.
Yes, Your Honor.
Okay, let me just make sure our timekeeper is all set. Excellent, thank you, Mr. Padalano. You may proceed.
Thank you. Good morning, members of the panel. May it please the court, my name is Natalie Hopple, and I represent the appellant mother in this appeal. Your Honors, the Indian child welfare notices sent by the department to the Cherokee tribes were not adequate. DCF's ICWA notices were deficient as to each of the 4 children, and in particular, the Tahlequah Cherokee tribe's response concerning the eldest child is inconclusive and should have resulted in the lower court ordering DCF to revisit its ICWA inquiry.
I'd like to ask you a question that I'm probably going to ask of all of you, and you may not know the answer, and that's perfectly fine, but it's my understanding that SCOTUS has an ICWA case pending before it. Does that bear at all on the issue that you raise here?
Yes, Your Honor, it does. It's the
How?
Brackeen versus Holland case. It's under appeal with SCOTUS. The decision is imminent. It could happen this morning at 10 a.m. The state of Texas as well, yes, Your Honor.
Breaking news, so they say.
I am checking it daily. The state of Texas, as well as some other southern states, are challenging ICWA in its entirety. It is based-
Including the notice requirements?
They are challenging the entire statutory framework, saying that Congress exceeded its plenary power as well as its Commerce Clause power, and it should be repealed in its entirety.
Okay.
As well as the placement requirements of ICWA for children who are deemed to be Native Americans. So it is in flux at present.
So in this case, once the first notification goes out and you get back what you get back from the Cherokee tribe, what was supposed to happen next that didn't happen in your view?
I think, Your Honor, one way to look at this is in terms of other states that have codified ICWA and have a lot, I think, more breadth of direction. I would look to the state of California and specifically language in the Judicial Bench Guide from the state of California. There's a 2023 Indian Child Welfare Act Bench Handbook. And in that
That's cited in your brief?
it is not, Your Honor. I'm happy to submit a 16L letter in support of that.
Did the judge below have it?
No, Your Honor.
I don't think we can have it.
In terms of the case law that's cited for notice in other states, would that be something that this court might enter?
In your brief?
No, Your Honor.
I'm sorry to interrupt. I do see in your, I just want to make sure this is a different thing from what you're talking about. On page 41 of your brief, you mentioned the Judicial Council of California ICWA information sheet. Is that different from what you're talking about now?
It is, and that is part actually of the whole ICWA. In terms of California, they've codified ICWA. So after 1978, when ICWA was enacted, California codified it as state law separate and apart and actually enhanced the burdens of ICWA. So that council sheet is somewhat of a guide for judges in that instance that derives from their entire statutory scheme in California. But I can turn the court's attention in terms.
Does that change the answer to the question of once they received back what they received from the Cherokee tribe, what was DCF supposed to next do that they didn't do?
So in terms of what was received next, what I can point the court to is that the trial judge, when those notices were filed into the Boston Juvenile Court, the trial judge was under ICWA's statutory framework required to review those notices and ensure that they have meaningful responses from the tribes that make a determination. So to the extent that the lower court did not go through and review, is what we're arguing, the ICWA notices to ensure that there was sufficient information provided to the tribes. As to all 4 children, that was something deficient in the lower court. But as to the eldest child specifically, the Tahlequah tribe responded saying, we are unable to make a determination about this child based on the information you provided because it did not contain information about a biological parent.
And on what do you base, what portion of the statute or the regs do you base your statement that the court had that responsibility?
So statutorily, we would be looking at 25 U.S. Code and it's section 1912. It is also regulation 25 CFR 23-111. And in terms of the court's duty with respect to the oldest child, CFR 23107, it's 25 CFR 23107, indicates that if there's reason to know a child is an Indian child, but the court does not have sufficient evidence to determine that the child is or is not an Indian child, the court must treat the child as an Indian child unless and until it is determined on the record that the child does not meet the definition of an Indian child. So that indicates that there's an ongoing burden that if the ICWA notices are deficient, then the lower court has the obligation to treat the children as Indian children until such time as the ICWA inquiry has been completed. And in terms of the eldest child, Your Honors, I think what might be helpful is very carefully, without mentioning names, it is in EA1 at page 72, and it's with respect to the eldest child where the Cherokee Nation states, it is not possible to determine Indian status per ICWA without information on a biological parent. This letter also indicates that, this letter is to make you fully aware of this possibility and to remind you if tribal affiliation is validated prior to the completion of the court's involvement, it could affect placement, priorities, procedures, and the levels of evidence required by the court and service providers. And then the letter goes on to say, this determination is based on the information exactly as provided by you. Any incorrect or omitted family documentation could invalidate this determination.
But how is it, so DCF can only, to some degree, rely upon the information that they have, right? So Plum says they're not Indian, correct? And then they do send out a notice. And in none of the return letters does it appear that any of the children have any, I understand the one letter says we can't tell from the information, but it's what DCF had. So I'm not sure, I can understand your argument of what would have been better, but I'm not sure where DCF violated any regulation or any statute by sending out the necessary notice based upon the information that they had.
Your Honor, if I might, I think what our issue or our argument would be to that, or response to that would be to say that the information is our argument, the lack of information, the lack of exploration, which the burden is placed by ICWA on DCF to investigate a family's Native American heritage if there's reason to know. Yes, I understand that in 2017, Mother made a statement to a DCF worker saying she was not of Native American descent, but that was 2017. The notices went out in 2018. What's not in the record, which I am not necessarily aware of, is what else is in the department's records that might indicate a reason to explain why, after a parent denies Native American heritage, a letter was then subsequently sent out to the tribes.
Did any member of a Native tribe come forward as a possible kinship placement? Do we have anything about that in the record?
There in the record, there was a motion filed by Mother to place the children with kin down in Georgia or Mississippi. I believe it was. That motion was denied. I believe the department did reach out to kin, but did not go any further.
Do we know if any of them were Native American?
We do not know from the record. I want to be very careful to stay within the
Understood.
record and not go outside of it.
Appreciate
But
that.
we do not know. And I think this goes to the idea that the record does not necessarily support that there was a breathtaking ICWA inquiry. I think one thing that I did take a look at was the Native American application for membership for the Cherokee, specifically for the Tahlequah tribe. And in that application, it does state that if you're looking up lineal ancestry and higher up in the ancestry, no one is a member of the tribe, you're required to go back to the Dawes rolls, which were, I believe, 1898 to 1914. That is a database that I believe the Oklahoma Historical Society has, as well as the National Archives, and you can search ancestral names to find that information. So it's incumbent, I would believe, on the department to comply with ICWA to understand some of the inquiry that needs to take place to look into this family's heritage.
Unfortunately, you are out of time. I will tell you that SCOTUS did not decide the case today.
Thank you, Your Honor. Thank you.
Mr. Ferguson.
Good morning to the court. My name is Hugh Ferguson. I represent the two eldest minor children.
Which
and may
we're
it
calling
please-
1 and 3, right?
1 and 3,
Okay.
correct, Your Honor. May it please the court. As detailed in my brief on pages 22 and 23, I filed a late notice of appeal because in my review of the record, I had not found notice of appeal having been filed for these two young ladies. That motion was allowed in part and denied in part, and I was instructed to request from the panel whether I'd be allowed to submit substantive argument, and I am asking for that at this time.
Well, why don't you present your argument, and then we will determine how to
Very well,
address
Your Honor.
that. But in cases like this, and I think it was just a ministerial problem, I'd rather know, I think, speaking for the panel, what your view is on behalf of these two children.
Absolutely, Your Honor. So my clients at the time of trial were 14 and almost 11. That makes one of them now 16 and the other 13. And we're not contesting mother's fitness at this time, but what we are contesting is the termination of mother's rights and the inadequacy of the plan developed by the Department of Children and Families.
Because recruitment is the plan?
Recruitment is the plan, Your Honor, and that's a very shallow plan. If I could just speak to that, the department's plan was adoption by recruitment. They did nothing more than make that plan and then subsequently stated, and I'll quote, "The department does not feel it is appropriate to include either sister in recruitment efforts such as adoption matching parties or recruiting videos." What that in effect did was say, we have a plan for adoption, but we're not going to advertise these young ladies. We're not going to let them participate in anything in order to get them adopted. Additionally, I would state, and
Isn't that because they weren't yet freed for adoption? Is that unusual?
their being free for adoption does not require, their being free for adoption does not forestall the recruitment process, Your Honor.
No, I understand it doesn't forestall it, but is it unusual to wait with children who are the subject of an ongoing?
Not to my experience and not to what I have seen, Your Honor. The adoption goal is made, and then the department should be pursuing that goal, and that would include those adoption matching parties and publication. I would argue further that this goal was both illusory and skeletal. Illusory because we've got two children who today must consent to an adoption. They consistently have said they do not want to be adopted. The goal is incredibly vague, saying adoption by recruitment and then stopping that opportunity. And over the 18 months from the removal in December of 2019 to the time of trial, the older sister had been in 5 foster homes, had never formed an attachment that would support adoption. And the younger sister had been in no fewer than 11 foster homes, and again had not attached to any of those homes in order to start that adoption process. And again, they had argued clearly that they did not wish to be adopted. That renders my clients legal orphans because of both their age as well as their inability or decision to not be adopted. And this court has ruled a number of times on legal orphans, and I would look specifically to the adoption of Gertrude. And in Gertrude, the children at the time of trial were 9 years old and 12 years old, where mine were 13 and 11. In Gertrude, none of those children had voiced an opposition to being adopted. Neither of those children had behavioral issues. Those children were noted to be particularly resilient, and that's a quote from the case. And those children were placed with a family friend. Presumably that would mean they would have some ability to have contact later with their mother. In contrast, my clients were 14, 11 at time of trial. Today, they are 16, and the younger will be 13 next month. Again, there was my older client had been in 5 foster homes. She is particularly stable right now. However, it's not a pre-adoptive foster home, and she will be turning 18 in a relatively short period of time.
I thought she had just turned 16 in March.
She turned 16 in March, Your Honor. So.
She may think it's a short time until it's 18.
Yes, Your Honor.
But any parent will tell you it will feel like forever.
As a parent, I agree with you absolutely, Your Honor. The younger child is an even more difficult case. She's going to be 13 next month. She's been in 11 foster homes throughout her young life. She and her sister have a very tight bond. She and the sisters and their mother have a very tight bond. Their mother is the only person that they have in their lives.
Right, but isn't the catch-22, and I appreciate that you're not challenging her fitness. What would you have us do in this situation? If I was the trial judge and gave you the pen and said, write the decree, what would you say?
I would say the department has a not viable goal, and perhaps that goal should be changed to what's called APLA, another approved permanent placement arrangement, and start working with these young ladies on how to transition into adulthood.
Is that precluded by a recruitment adoption plan?
I don't believe it's precluded, but there's nothing in the record to say that they've done anything to start working towards that. And again, this young lady will be 18 very shortly.
Right, the older one, it's more likely, right, than the younger.
Yes, correct. And Your Honor, I think that their trial attorney probably said it best when she stated the only consistent, if deeply flawed parental figure these children have in their lives is their mother. That's in the transcript at page 1564. And this court found in the adoption of Flora that, quote, even if a parent is found unfit, and there are some situations in which a child's best interest may be served without a decree of adoption. This is such a case. These children do not need, nor do they want, to be adopted. And I see my time is out, and subject to any questions,
We will have to take the rest of the argument on your brief. Thank you very much.
Very good. Thank you, Your Honor.
Attorney Braithwaite, are you going to go first?
I believe so.
Okay. Can you start with ICWA?
I absolutely
I know you
can.
ended with it in your brief, but I'd like you to start with it.
Okay. Members of the panel, may it please the court.
That's right, I'm supposed to let you get your name out before I ask my first question.
I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I am here today to start with ICWA. I do think I want to initially respond to a question that I suspect may be forthcoming based on what Your Honor said, but I want to indicate that I disagree that the outcome of Brackeen v. Holland has an impact on this particular case. The challenge to Brackeen v. Holland is with regards to its constitutionality as a whole. And while I will acknowledge that if ICWA is struck down, any findings that may occur under ICWA would be rendered moot. But the questions here are not around the constitutionality of ICWA, they're around the procedural appropriateness of the court's handling of ICWA, and I think that can be addressed entirely without looking to Brackeen v. Holland. So I would respectfully disagree with my sister and indicate that
So no reason to stay this is
no
your
reason
view.
to stay
Okay.
this. No, I think all of the questions exist on the exist on the record. Now, I want to sort of acknowledge, Mother accuses the lower court of failing to ensure that ICWA was complied with, but I think the record is very clear that it was. The standard for determining an Indian child is laid out in 25 CFR 23.2. A child is an Indian child pursuant to ICWA if they are a member of a citizen of an Indian tribe, or if they're eligible for membership or citizenship in an Indian tribe and are the biological child of a member citizen of an Indian tribe. And I want to indicate that the guidelines put out by the Bureau of Indian Affairs regarding this explicitly states that ICWA does not apply simply based on a child or parent's Indian ancestry. Rather, the child or biological parent must be enrolled for ICWA to apply. That doesn't mean that procedures do not need to be followed, but I think it's important to keep that as a framework for assessing whether ICWA did apply here. Now, Mother has been asked on the record that we have before us on 2 instances whether or not ICWA applies. One of those instances was April, I believe, 19 in the court, and she indicated that's at Record Appendix 1, page 15, Record Appendix Volume 1, page 15, and she reported to the court that she was not Indian and the children were not Indian. She was also asked on June 9, 2017 by her response worker, in light of the fact that there is some notation in the department's record, whether there was any Indian affiliation, and I would direct the court to Record Appendix 2, pages 339 to 340, where Mother again resoundingly states that she is not Indian, the children are not Indian children.
Counsel for Children 2 and 5 say that this issue is waived. You didn't address that in your brief. Do you think the ICWA issue is preserved?
I think that Mother did not raise the ICWA issue, and in fact certainly didn't object and agreed that it wasn't accurate. However, I do believe it was waived. I think that nonetheless, if
Even if.
the panel would like, but even if it wasn't waived, I think that it isn't a strong argument, and I would like, given that a lot of attention is on this issue, I will proceed however the justices would like. I do think it's waived. I also think there's value in having the conversation. I want to respond to a question that you asked, which is what are the requirements? What is incumbent upon the court to do in cases where there's a question of ICWA? At the outset, and this is across the board, whether there's any question of Native ancestry, all parties to a case in a child custody case have to be asked on the record whether ICWA applies. That's step 1. That did happen here. Mother indicated no. If there was no other reason to believe ICWA applied, that's done. ICWA has been complied with. There's no more conversation. But the statute goes on to say that if there is reason to know, but the court has insufficient evidence to determine, then the court must confirm by way of report, declaration, or testimony that an agency or other party used due diligence to identify and work with all of the tribes of which there is reason to know to verify whether the child is a member or the biological parent is a member and the child is eligible for membership. Here, where the record unfortunately does not tell us where ICWA first popped up in this case, and I scoured it and wish I could give information, but I can't. But it is in the record that the department has indication of this Cherokee affiliation. So despite Mother's reporting no ICWA, it was incumbent upon the department to then send out notices. And I would just direct...
Just to the Cherokee tribe?
Just to the Cherokee tribe, because all notations are only to the Cherokee tribe. And the ICWA statute is clear that you only need to contact those tribes which there's reason to know. I would add, however, that when there is some question, the courts are the notices are also sent, I have it somewhere. It was sent to the Eastern Regional Office of the Bureau of Indian Affairs in addition to all the Cherokee tribes, and that's to say if you have any other information that would help us.
So that's overarching, that's not just Cherokee.
Correct. So all of the federally recognized Cherokee tribes, as well as this Eastern Regional Office of Bureau of Indian Affairs, and that's at Record Appendix 2, page 63, in order to seek any assistance that may garner further information. When that notice was sent to every legally recognized tribe, it came back that the children were not eligible. And I do, if it's okay, I would like to take a moment to address, I believe it's child 1, but the oldest child. There was a letter that indicated that that could not be confirmed or denied. That is explicit in the letter that that is a function of the unidentifiability of the father. All of the concern about ICWA eligibility in this case rests with the mother. The same tribe did respond with the mother's information and all the siblings' information that there is no eligibility for enrollment. However, we do not know child 1's biological father. There's no one on the birth certificate, and mother has not been forthcoming with a name, and there are limits to the ability to provide information. I would argue that what mother seeks is to add an investigatory duty on the court, which is not called for. And again, I don't want to take my time repeating myself, but I would point back to 25 CFR 23.107, which is specific that the court looks to the agency to do due diligence. And though there's suggestion that the agency did not do due diligence, the notices are populated with information provided by mother. They are provided by mother to ensure adequacy. And so there is no, the record is clear that the department followed to the best of its ability.
I know your light is blinking. I know I have a question. Does the recruitment plan for adoption preclude an APLA application?
No, an APLA application, so that's a different plan, but it can engage with concurrent planning, and it often does in instances where there's concern. I'm happy to briefly weigh in on the older children's adoption.
I think you've answered my question.
Okay.
Thank you very much.
Thank you, Your Honors.
I believe we're going to hear from Mr. Rosenthal next. On behalf of Child 2.
Not sure how the children are numbered, Your Honor, but my client is the 4th child in the birth order and the oldest male child.
Gotcha. Thank you.
Good morning, members of the panel. My name is Stephen Rosenthal. As I said, I represent that 4th child in the birth order. Without getting too far into my 4-minute cameo, I do want to emphasize and second what my sister just argued, which is that in Record Appendix page 15, the docket entry for April 11, 2019 specifically states, and I'm quoting, "Parties respond no as to knowing or having reason to know child is an Indian subject to ICWA." And my take on this is that the parties, meaning mother, has an equal obligation to give the court, to have the court know or have a reason to know that the child is subject to ICWA. And as I argued in my brief, the trial judge doesn't have a separate duty to investigate, only if a party informs the court of a reason to know. Now, if I may, I'd like to speak about my client specifically. My client is currently 8 years old. He has been diagnosed with severe PTSD and reactive attachment disorder, due in large part to the violence he was exposed to in mother's care. He was very close to his younger sister, whom he referred to as his baby. I'll refer you to Exhibit Appendix Volume 2, page 191, also finding of fact 331. He was excited to pick her up at daycare and for them to ride together in a car. At age 4, he watched as his sister deteriorated over several days and was hospitalized. He saw her intubated and non-responsive in the hospital, and he later reported that mother beat his sister. She couldn't breathe. That's how she died. That's at finding of fact 86 and 324. The fact that she couldn't breathe stayed with him. He later asked a foster mother if his sister died because someone held her by the neck and said that mother sometimes did that to him. That's at finding of fact 315. My client's sisters death had a profound effect on him. He was reported to have tantrums and to engage in assaultive behavior in foster care and in school, directing you to Exhibit Appendix Volume 2 at page 239. The findings from a neuropsychological evaluation indicate that he sees the world as threatening and unsafe. He is hyper-responsive to minor disappointments. He lacks a sense of security. He needs long-term predictability and reliability, which mother has not provided and can't be expected to provide for the foreseeable future. It's my position, Your Honors, that the termination of mother's parental rights were completely appropriate in this case. There have been some developments since the trial took place affecting my client's placement. I won't get into that because it's outside the record, but I would ask that the court affirm the decision.
Thank you, counsel.
Thank you.
Attorney Parker, on what I believe we've labeled Child 5.
Yes. She was born, she's a third of the children, and she was born 3/19/2013. Good morning, Your Honors. There's no error in the termination of the mother's parental rights due to her extensive history of domestic violence, neglect, criminal history, and mental health history. My client was born on March 19th, 2013. On December 20th, 2016, the paternal grandmother picked her up at the mother's request and noticed that she, then age 3, was wearing a diaper despite being toilet trained, and that she was bleeding from her vagina. I'm just going to pick a couple of incidents that pertain to my client. Because she continued to bleed, the paternal grandmother took her to the Boston Children's Hospital, where bruising was noticed on her upper arm, medial knee, redness on her chest, as well as blood in her urethra. There was also foreign hairs present in the folds of her vagina. On February 20th, 2017, a 51A report was filed alleging neglect of my client and the other children but particularly my client, when the mother got into a physical altercation at Chuck E. Cheese, during which the mother, because of the security tape, they know the mother started it by throwing a chair, which hit my client and ended up with a 2-inch wound on her forehead from the object thrown by the mother. She was brought to the emergency room with deep, gaping forehead laceration. On December 20th, 2019, after having been out of custody of her mother since February 20th, 2017, she was reunified with the mother after her siblings had all already been there because she was having a difficult time being separated from her siblings, especially her sisters. She was only reunified for about 1 week prior to all the children being removed due to what happened to Child L. While being at the mother's, she was exposed to domestic violence between the father and the mother, Father F. After L's death, she returned to live with her father. She had been living with her father prior to being reunified with her mother for that 1 week. And social worker Johnson testified that it's very clear that she has a strong bond with her father. He's affectionate and attentive. It's very apparent she feels safe and loved. She's always very happy and well cared for. Her hair is done. She's got clean clothes. You can tell she's just a happy little girl. This is for the time before she was reunified with her mother for the week. The observations of the social worker. There were no academic concerns. She was at grade level. Social worker Martin described my client and father's interactions as great. He's very supportive, helped her with her homework and provided food. He was very understanding of how she was feeling about things. And when she said she wanted to be with her siblings, he reluctantly agreed to that. At her SANE interview on January 20th, 2020, my client reported that the police came because Elle was dead. Her older sister said that Elle did not eat on Christmas and struggled to swallow food and had stopped talking and singing. The court found the children were traumatized by observing Elle's health deteriorate, which is an understatement.
I think we're
They
going
were
to have to leave it
traumatized.
there, Attorney Parker, unless the panel has any additional questions.
Does the panel want to know what happened with Mother's criminal case?
That's not before us, it's not in the
Okay.
record. Thank you all. This is a very sad and tragic case. It is under advisement, and thank you all for helping to explain the issues to us.
Thank you, Your Honors.
Feel free to send in a 16L letter when SCOTUS rules. Our next case is also a DCF case, so it is impounded. Please do not use any names. That one is docket number 22P0483. Mr. Catalano, are you all set with those? Okay. As I understand it, as people are approaching, mother and father are splitting their time evenly, 7.5 each. The department, 10 minutes, and child's counsel, 5 minutes. That's my understanding. Okay. When you're ready, counsel.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant father, who is asking this court to reverse the judgment, terminating his rights and freeing his children for adoption. The trial court erred in not applying the constitutionally required standards to permanently sever parental rights. First, there must be clear and convincing evidence of parental unfitness, and second, termination of parental rights must be in the child's best interest. And these two factors are integrally related. So at times, even when a parent has significant deficits, it may be that it's not in the child's best interest to terminate parental rights. And I think that's especially true as was the case at the time of trial with the older child. There's no identified adopted home. So with regard to the question of unfitness, I think the father would be the first to admit that he's not perfect and he's had setbacks. But a parent does not have to be perfect or without flaws. Doesn't even have to be a good parent. It doesn't have to be as good a parent as a substitute caregiver. The question is whether the parent puts the child much at hazard. Now, in this case, the evidence shows that until the point when DCF changed the goal to adoption, the father was on a very positive trajectory. He was making very extensive efforts to visit with the children. He had developed and maintained a significant emotional bond with them, and that's despite a number of factors kind of working against him. First of all, he wasn't the custodial parent from the outset, and they were removed at a very young age, but nonetheless, he was able to develop and maintain his bond. I would say that during this period, it was DCF, not the father, who was putting the children much at hazard. While the trial judge put a lot of responsibility for the children's trouble on the father in the findings of fact, the fact is that the children were yanked from their home at a very young age. They were separated from both each other and their older half-siblings, and likely are never going to live together again. Each of them was repeatedly removed from one unfamiliar home and placed in a new unfamiliar home. And the wear on especially the older child was apparent. He ended up for a time in the hospital. And when the trial ended, there was no certainty as to where he would end up. So the court needs to evaluate the father's missteps against this background. Yes, he did backslide after hearing that children were, the plan was changed to adoption. But the question is whether there was harmful behavior whether there was harm to the children attributable to his behavior. And I think, a careful look at the record shows that his criminal behavior was significantly less serious than his prior criminal history had been. So it's absolutely true that he continued to have several periods of incarceration, but this time they're measured in months, not in years. As for substance abuse, it is also true that he went into recovery several times, but substance abuse is a disorder in which multiple attempts are often needed in order to recover. And the father showed a commitment to continuing to return to treatment.
So one of the things you say in your brief, and I recognize that you didn't write the brief,
Right.
but you say that when the father learned that the goal had been changed, that caused the father's relapse. And when you think about raising children, unexpected things happen all the time. There's a problem at school, there's a problem in the neighborhood. I'm concerned about what his response would be to return to something that we understand is a disorder. If there's some kind of a challenge that the child faces in the ordinary day of being a child today. So, I compare the two in my head and think, if that caused him to relapse, isn't that a concern?
Well, I think in addition to the change in goal, then we had a significant cutoff in the amount of contact he was able to have with the children. And so, now some of that was due to his own problems, but at a certain point, due to the pandemic, which of course is beyond everybody's control, but DCF did make a unilateral decision that they were not going to allow in-person visitation. So at this point, he's not getting the in-person contact.
Were the video calls happening at that point?
So there were video calls, which with children this young, you can
Not
see
perfect.
the issues. You can see the issues with video calls with children this young. And one of the children started to resist the video calls. And so DCF said, well, just phone calls, and we're going to apply that to both the children. Now, DCF is required statutorily to make reasonable efforts and not to thwart efforts at reunification. So it is true, and the father does have to show some resilience to bad events. But this hearing that that DCF, they changed its mind, that first they were going to reunify with the mother, and then they said, no, we're going to make you the resource. We're going to place the children with you. And then all of a sudden, certainly in his view, it's, no, we're going to move to cut off your parental rights altogether. What I would say about the father, since my time is coming to an end, is that the court found there was a significant emotional bond between the father and his children, to the point where it did order a post-adoption visitation. I think that's significant bond. When you look at all of the court's findings put together, it just does not amount to the kind of parental unfitness that justifies termination of parental rights, and that termination is not in the best interest of these children. Thank you.
Thank you, counsel. Good morning.
Good morning. If it please the court, my name is Christine Hamilton-Quiros, and I represent the appellant mother. She is also requesting that the court vacate the decree terminating her parental rights. Keeping in mind the backdrop of father's appellate attorney with the struggles finding placement for the children together or apart. This morning, I would like to focus on how mom, in this case, she was on her way to being fit. She had done many, many services. She'd done every service that they requested. The department never changed their service plan. If there was an issue, they could have sat down with her and figured out, what else do we need to do? They didn't do that. She just kept doing the services. She was compliant. The court cannot terminate a parent's rights unless there's evidence that clearly and convincingly demonstrates that the parent is not only currently unfit, but will be unfit into the indefinite future.
Well, let me ask you, at the time of the trial, she was in a relationship with somebody that, at least as the department suggests, that was violent. She was arrested for drug offenses during the pendency of the case, and notwithstanding the services that she did, the department's view is she didn't gain any insight into her behaviors, and that is demonstrated by her continuing in toxic, unhealthy relationships and drug use. What is your response?
Well, those are good points. Mom would say that although the department felt that she was in a toxic relationship, she would say, and she did say, she was not in a relationship with that person, and that the evidence that came in about that person was improperly admitted. She doesn't know anything about his Corey. She has no ability to...
Was there an objection at trial to that evidence?
Her trial attorney did object to it, but it came in over the trial attorney's objection. Not only that, she doesn't have any knowledge of what's supposed to be in the carry. She has no knowledge of how to dispute anything in the carry.
But even setting aside the carry, I mean, I understand there was an evidentiary dispute over that, but there was other evidence of her partner or recently former partner's violent and substance use tendencies, right? I mean, he was reported to have shown up at DCF's offices in a state of intoxication, to have refused to stop coming to the offices when he was asked. The police had been called for domestic violence between her and him. So even if one were to set aside the carry, it's not as if that's the only thing in the record.
While that may be true, she has no control over where he goes. She was not in a relationship. She would have said that she's not in a relationship with him. She was not in a relationship with him. And she did do services to address those concerns. She did domestic violence courses. She did domestic violence groups. She attended every service that the department asked her to do. She was very compliant. Even during visits with the children, when the children would bring things up, she would redirect them. She was
Let me ask you about that, though, because at conclusion 27, the judge says that the gentleman has choked mother, broken her phone, slammed mother's head into a door, and has threatened to kill her. Are you saying that that's not true, or that that's old information?
Mother would say that that is old information, that she's
How old relative to the trial? If you know.
I don't know I apologize, I don't
Okay.
know off the top of my head. I can provide
worry.
that in a 16L letter, but I don't have that off the top of my head. But she would say that through doing therapy, through doing her programs, including the domestic violence programs, the domestic violence groups, the domestic violence education that she received, she's learned how to recognize those things. And she was no longer in a relationship with anyone that would present a danger to her children.
I just want to follow up on the conclusion of law that Justice Blake just cited. In that same conclusion 27, the judge found that in 2020, the mother was engaged to this man. Is that not based on the record?
That is based on the record, but that's before the trial. That's before she did the last domestic violence groups, the last domestic violence program, that was before that.
But you agree, we look at the whole picture, correct? And so I'm not taking away from your client's interest in attempting to better understand and conquer her disorder and other issues. There are many indications, it appears in the record, of her unfitness. So I'm not taking away from the fact that at some point in time she engaged in a program. But how is that enough?
Well, Your Honor, unfitness does not mandate termination, And with the programs that she did and all of the counseling and the groups, she managed to make progress so that she was only, at the time of trial, she may have been unfit, but that unfitness was not going to last into the indefinite future. And the court has to find not only that the parent is currently unfit, but will remain unfit, and that it's in the children's best interest to terminate that relationship forever. And under the umbrella of the findings that the children were significantly bonded to mom, with all the services that she'd done and all of the efforts that she made to overcome her shortcomings, she was on the way to being there. She just needed a little bit more time. And the children,
Can I ask you about her lack of appearance at the trial? If I'm correct, there were 8 non-consecutive trial days and your client didn't attend 4 of them, is that right?
Well, my client was ill, and she did let the court know that she had COVID during that time.
So what happened with the Zoom? Because didn't the judge say, fine, we'll allow her to participate through Zoom? And then the judge didn't credit her explanation that she was ill.
Well, there was evidence in the record that mom, she's 51, and that she had trouble with technology. She needed assistance with it. She asked the department to help her with it, and she never actually got the help, trying to figure out how. She's not computer savvy, and there was evidence of that in the record. So it was not a blatant attempt to not.
We'll have to leave it at that unless
I
the panel has-
apologize.
Thank you.
Thank you. I'll rest of my brief. Thank you.
We're going to hear from the department first. Attorney Macris?
Yes, Your Honor. May it please the court. Among the extensive factual findings made by the trial court and the voluminous evidence that it considered, there are 3 things that stand out and that are beyond dispute on appeal. First, both mother and father have serious substance abuse problems that have spanned the last 30 years, and those problems were still afflicting them during the time period leading up to trial. Second, both mother and father have extensive criminal histories that span the last 30 years, and both of them were facing new charges and convictions that occurred after DCF had taken the children into custody. And third, and perhaps most troubling, in the lives that appellants would have children return to, there has been a rotating cast of men with a propensity for domestic violence. That includes father himself, who has had 7 restraining orders obtained against him by 5 different women. That includes the father of the children's half-siblings, who, similar to father, has had 5 restraining orders obtained against him. And that includes the mother's fiancé at the time of trial, a man she became romantically involved with after DCF had taken the children into custody, who has a range of violent criminal charges and convictions, including assault against a household member.
Was his carry improperly admitted?
No, Your Honor.
All right, let me hear you on that.
Yes, Your Honor. First of all, 2 responses. The only objection that was raised below was relevance. As to relevance, I think what the CARI shows is clearly at issue, which is that he has a violent criminal history. This person was engaged to the mother. That's a factual finding that the trial court made, and that there's no evidence in the record that hasn't been rejected by the trial court to the contrary. And based on that alone, there was a likelihood, or the trial court reasonably concluded, that he may have figured prominently in the children's lives, and that makes it relevant. Second, Your Honor, to build on questions you were asking during opposing counsel's argument, there was ample other evidence in the record of Mr. Kari's violence aside from the CARI. Just to cite a few examples, the social worker who testified that he had attacked mother and strangled her. That appears at page 843 of the trial transcript. Mother herself testified about an incident where police were called because he had slammed her head into a door. And as to when that happened, according to the factual findings, October of 2018, after DCF had taken the children into custody. Mother testified about yet another incident that appears at pages 570 to 571 of the transcript, where he violated a restraining order that she had filed against him. Now, Your Honors, both father's and mother's arguments raised on appeal at bottom are largely factual arguments. To start or otherwise questions about the trial court's judgment that is entitled to deference. To begin with, start with father. Opposing counsel mentioned that father had a backslide. The following facts were not in dispute below and haven't been challenged in appeal that show that it was far more than a backslide, and it was at least enough to place this within the discretion of the trial court. During the summer of 2021, in the months leading up to trial, which began in October, father was incarcerated for a period of 3 months in connection with charges for possession of methamphetamine. That was the third time in 3 years that father had been incarcerated for a period of months, all after DCF had taken the children into custody. At trial, father was essentially rotating through different drug treatment facilities. According to his own testimony, in early October of 2021, just before trial began, he was at a facility called Ryan House, but was kicked out for using fentanyl. The trial court found that as of late November 2021, just before trial ended, he was staying at yet another drug treatment facility. And by his own admission, he had been using methamphetamine just before trial started and was then currently relapsing. Your Honor asked opposing counsel about his ability to respond to changed circumstances in connection with his argument that this really DCF is to blame for changing the goal change to adoption. Respectfully, it is going to be harder, not easier, if father has the custody of children to address his substance abuse problems and the other issues that he's facing in connection with his criminal conduct. But beyond that, Your Honor, it was a factual finding there were factual findings on those issues that are entitled to deference. And
Do either mother or father argue that any of the judge's factual findings are clearly erroneous?
I would submit not, Your Honor, but at a minimum, they have not cited sufficient evidence to show that any of them are. And on that point, Your Honor, I'll turn to mother's arguments. Opposing counsel stated that DCF felt mother was in a toxic relationship. Again, there were factual findings that mother was engaged to the boyfriend or the fiancé at the time of trial, and there was ample evidence in the record to support that factual finding. As to father's argument that opposing counsel stated that DCF was the party that was placing children at hazard, and referenced some of the behavioral issues that one of the children was having after DCF took the children into custody. This again is an issue about deference. The trial court was faced with two alternatives. There's no contention in the record that the children being in foster care was the perfect situation or an ideal situation, but that was one of two alternatives that was facing the trial court. The trial court had to choose between placing the children back in the custody of parents or attempting to find adoptive parents for these children and taking some other course. And that's a judgment call. It's within the discretion of the trial court.
Can I ask you about the older plan? The older son's adoption plan seems extraordinarily vague to me compared to others I've seen. Do you have any legal authority that plan is both sufficient and compelling?
Your Honor, I don't have any specific case law, although I would argue that regardless of what way that issue cuts, it's a matter of discretion for the trial court. That determination is being reviewed for abuse of discretion. And given the alternatives that were facing the trial court, that should stand on appeal. Your Honors, I'll close with, unless there are any further questions, I'll just close by asking this trial court to affirm the lower court's judgment, which was predicated on factual findings that were well supported by the record and judgments that are entitled to deference on appeal.
Thank you. Good morning.
Good morning, Your Honors. Richard Shokire for the two children. May it please the court. The children are asking that this court terminate the rights of their parents and to affirm the lower court's rulings and decrees. These children both have special needs, as is reflected in the record, and these needs would be a challenge for any parent, fit parents, much less deeply flawed parents. The older child has behavioral issues that led to his displacement, and the younger child has communication skills that are both being addressed through speech therapy, individual therapy, and group therapy. There is an amalgamation of issues, particularly long, significant, and prognostic histories of domestic violence and substance abuse with mother and father that were not sufficiently addressed by the time of trial. Mother's domestic violence has been present in each and every one of her relationships. She kept a relationship throughout the pendency of the case that she made sure was furtive and misleading to the department.
What's the case that says that the child's special needs are part of the consideration as to whether or not the parents fit?
I know that case, Your Honor. I can't.
I'm not
think of
making it
off-
up then.
I can't think of it off the top of my head, but it is a factor in the consideration in the
Is
in
it
the
Jake's,
conclusions
maybe?
of law. No, it's not.
No.
But the special needs, a parent's abilities as per a child's particular needs, I think is what that case
I
says.
think it's Frederick.
Yeah. Father also was a perpetrator of domestic violence. All of his relationships evidenced significant domestic violence. The court found that there were multiple police responses to the house prior to the B3 removal, and correlated that the children were exposed to domestic violence. Of course, we have, I cite to Jacob and Vaughn as to the effects of domestic violence on the children. Mother's lack of insight is evidenced by her continuing and furtive relationship with her boyfriend, where that, in response to my sister's earlier argument, I mean, Mom was, I believe at one point, forced to go into hiding to avoid his trappings. With respect to their substance abuse issues, these were long-standing issues, and contrary to my sister's argument about how this change of goal somehow triggered this response, I believe that an alternate way to really look at that is that it more underscores what the judge found in her findings, that it is a pattern of substance abuse, attempted rehabilitation, and ultimate failure. So I believe that that is a more cogent way to look at that pattern of behavior. So we have patterns of domestic violence, patterns of substance abuse, and then we also have the visitation with the children. Mother would disappear for weeks or even months at a time. By the time of trial, and with all deference to the COVID pandemic, he hadn't seen the children in 2 years in person. And when the remote visitation did take place, the oldest child would often decompensate and would have, I believe one of them actually led to his hospitalization. So the parents argue that these were all issues that were not relevant because the department did not see the services they were doing. But a lot of times they were blatantly disregarding all of these services and lacked insight. And I believe that Mario states that their blatant disregard and lack of insight can't then be used at trial as a sword for which they can, just as if I could correlate it to a criminal case where they could throw up their hands and say, there's no evidence. I see my time has expired.
It has. We'll take the rest of your arguments on your brief. Thank you very much, Counsel.
Thank you, Your Honor.
It's a difficult case, and all of the arguments were very helpful today, so thank you. While we get set up on the next case, Mr. Garino, can I see you first? As the next case gets set up, I know we have a number of students in the courtroom and other guests. This is a particularly emotional case, and so if you need to leave the courtroom and take a break, if you're in the audience, that's perfectly fine. Mr. Beeler, is your client in the courtroom?
No, Your Honor.
Okay. So our last case on the list this morning is Shannon PARADIS versus Martha Frost and another, docket number 22P775. Mr. Beeler, when you're ready.
Thank you, Your Honor, and good morning. My name is Jeffrey Beeler. I represent Shannon PARADIS, who is the personal representative of the estate of her 16-year-old son, Jake Goyette. On July 13, 2018, Jake left his home in the early morning hours with a shotgun. He went into his tree fort. He became the 6th Acton-Boxborough Regional School District student to die by suicide in a 2-year period of time. 2 months later, the phone rang at their home, and it was an administrator from the high school, making, I expect, what would have been one of the most difficult calls an administrator needs to make, disclosing to the family some of the information that was in the possession of the Acton-Boxborough High School and its personnel about 6 weeks prior to Jacob's death.
That call was not from Ms. Frost, is that right?
That's correct. I believe it was the principal of the high school who got that difficult chore. The phone call came in, an investigation began. This case ultimately got rolling. And what we found out, even before we filed the case, was that 6 weeks before the the death, Jacob's girlfriend, herself a child, went to the Commons at the Acton-Boxborough Regional High School and saw Jacob drinking vodka, upset, crying, unable to speak with Jacob about what was wrong. She told him, I'm going to go talk to Martha Frost, who she had been counseling with herself for problems she had, associated in part with issues she had with the other suicides that had occurred. She knew some of the other victims. She went to Ms. Frost's office, interrupted an ongoing counseling session, said it was very important. The other student was removed, and she disclosed information to Ms. Frost at that point in time that included the fact that Jacob, while 16, was drinking on school grounds, was crying, upset, had not been acting himself, that she was concerned about him for a number of reasons, including the fact that his conduct was reminding her of the conduct of a previous suicide victim, and she was concerned he was going to hurt himself and do something stupid. At this point in time, Ms. Frost, an LICSW, working as a social worker at the school, told this child the following: don't worry, I'm going to talk to Jacob's parents, I'm going to talk to the dean, we're going to get Jacob the help that he needs. That's a pivotal point in this case, because as of that point in time, up until that point in time, that affirmative intervention by Ms. Frost, Jacob's situation was that his girlfriend was going to report it to the school, which is exactly what these students had been trained to do in the wake of all these other suicides.
And that happened on May 30, 2018.
That's correct. She was going to report it not only to the school, which is what they've been trained to do, but to Jacob's parents.
So what evidence do we have in this record about what the school policy had been as communicated to the students in view of the number of suicides?
I believe there are policy materials that are part of the record appendix, Your Honor, that talk about that issue, and I believe it was pled that way in the complaint. I'm not here on a summary judgment motion here. I'm on a motion to dismiss standard.
Under immunity.
That's correct. But my complaint and the allegations of the complaint must be accepted as true.
Right.
All the reasonable inferences have to go my way at this juncture in this case, which is one of the reasons why the Superior Court's decision needs to be reversed, because that's not what happened at the Superior Court. But going back to this situation where Jacob was going to get the help he needed, according to the complaint, help that in the complaint that is pled, and I would suggest that the experts ultimately in this case will confirm, saves lives when it's brought to bear at the appropriate time. Saves lives if it's brought to bear before the kid is walking out to the tree fort with a gun. And what happened was, because this adult told this child affirmatively, don't worry, I'm going to deal with it, the child did what I think is absolutely predictable in this situation. Nobody likes to talk about suicide. People talk about it in euphemisms. It's a big deal to get a child that age to walk in and make these disclosures to an adult thinking that another child is going to get help. And what happened was she said, okay, the adults have it. They're going to talk to the dean. They're going to talk to Jacob's parents. He's going to get the help he needs. She didn't make that phone call. She didn't tell the parents. The parents didn't know. 6 weeks later, these events happened.
She did speak with the child, correct?
I'm sorry?
She did speak with him?
Her testimony in the case is, well, yes, in the complaint it is alleged that he did come in and there were certain representations made about what was said. She did meet with him briefly. The case has gone on against her. I would suggest that there was no risk assessment done, although the evidence is in conflict in connection with that.
What day did she speak to him?
That day.
May 30.
Correct, that day. No documentation of it, zero documentation of it. She claimed ultimately when we were doing our investigation not to even know who the student was who came in and gave her the warning initially. That's the facts in this case.
But all we have in the complaint is paragraph 31. Reportedly, after meeting with the girlfriend, Frost did meet with Jacob, establishing a social worker-patient relationship with Jacob.
And that is effectively what we knew at that time. We know a lot more now, which is part of
That's how
part of the
litigation
issue.
goes.
So you want us to apply, I assume, the MIT case to the facts here, right?
Yes and no.
Well, in thinking about, and I want to hear the yes and the no, but just to help inform your comments, I'm wondering about if this was a high school where the children lived, so a boarding high school as opposed to what we have here at public high school. Does that make a difference here in terms of its relation back to the MIT case?
Only if you look at these schools as custodial institutions, which I would suggest that the Wen case said isn't the proper analysis. Wen talks about custodial analysis being limited to true custody, the jailer and inmate. When somebody's locked up, they have no control whatsoever. Now, in the record or in the materials we filed, there is a decision from a case out of Connecticut we're handling, the Fitzpatrick case, that is a boarding school for special education students. You can see what the Superior Court said there about those issues in that situation. But I don't think it should make a difference under Wen, because the
special relationship exists regardless of the fact that when the bell rings at the end of the day at Acton-Boxborough, the kids go home to their parents.
Absolutely, Your Honor. If the information is disclosed at these schools, the schools have an obligation, especially about student safety, they have an obligation to convey that to the parents so that there can be essentially knowledge going both ways. They can't sit on that information. And, you know, I come to you not only as an attorney who's handled these cases before, but as a former school committee member in a contiguous community to these ones. I know a little bit about how these institutions work. They can't turn a blind eye to the fact that if they know about a risk of serious life-threatening harm to these students, they have to let the parents know.
But we don't even have that in the record, do we? I mean, that part of the issue legally is whether or not high school has a duty to prevent suicide, if there's a special relationship, and you make the arguments. But this record, we have the licensed social worker speak to the child. Now, I don't know. Maybe the girlfriend was not accurate. Maybe the girlfriend had issues herself, or maybe the licensed social worker said, I'll work with you too because you're not a risk. And so there wouldn't be the trigger to call the parents and say, somebody just reported he's suicidal, but he's not, correct? And we don't have that in this record.
I would suggest in the record you have a complaint that says that that was the rule and that was the policy, and that's what should be evaluated at this point in time, Your Honor. You're right. There's a lot more facts that will be developed, and it will be presented at summary judgment and certainly at trial, but the appropriate time for them to be weighed is at summary judgment and ultimately at trial, when it's going to come down in many ways to a jury's assessment of the testimony of the witnesses in this case and who they believe about what was said.
But as a matter of law, how do you make the leap that immunity does not apply?
Well, I want to go back to the duty issue because I think that's what we're actually talking about, and I'll get to the immunity issue just momentarily because it comes back to that yes or no answer on when. When was talking about duty of care in connection with a graduate student, 25 years old, at a graduate school where some of the deans have been quoted in the past as saying to the New York Times Magazine that that school, or some people at that school, take a quiet pride in the fact it's so difficult that students are being driven to their death. The SJC said in when that the relationship needs to be analyzed in connection with the nature of the relationship between the student and school. When related to a 25-year-old treatment adverse and he didn't want help student and a graduate school. This is a high school involving children. Section 40 of the Restatement Third of Torts specifically says, in the comments under the rule relating to the special relationship existing between the school and the students, that it's essentially relationship dependent. You need to look at the age of the kids. You need to look at the type of school it is. To Justice Blake's question, if it was a custodial or a residential facility, that would increase what they should be doing. But it doesn't undercut the existence of a duty of care.
But looking at when, it limits, right, it's, the SJC took pains in that case to say, we stress that the duty here, at least for non-clinicians, so putting aside Ms. Frost, who's aside anyway, is limited. It is created only by actual knowledge of a student's suicide attempt that occurred while enrolled at the university or recently before matriculation, or of a student's stated plans or intentions to commit suicide, and then it goes on. And so I think, just to circle back to Justice Walsh's question, in the complaint, there is no allegation either that the young man had attempted suicide recently or that he had stated plans or intentions to commit suicide. Is that true?
It talks about actual knowledge, Your Honor. Actual knowledge can be inferred from other conduct and other information. It does not need to be an admission from the person at risk of suicide. And making that the rule is going to cost lives. That's not the way students in particular report suicidality to people when they have it. They just don't talk that way. They don't walk in, sit down, and say, at such and such a date, I'm going to go to such and such a place and kill myself this way. And if they do that, they're going to get the help they need, and there's going to be no case. So there are times, of course, when that probably happens in the context of a therapeutic relationship. But when these kids are reporting this information, it requires the other people, the gatekeepers, if you will, to the mental health care that they need, to be willing to make the obvious leap. There was a suicide contagion at this school that had cost the lives of 5 other students, or recent students, before this young man had this happen. Martha Frost got this information. She should and knew that this was of such a sufficient risk. She told the other child who was reporting not to do anything about it, or essentially she had it. She was going to report it and get him to help. She responded as though she understood that risk. The jury would be able to infer that, certainly with her training, since that's what we're dealing with, that she perceived and knew of that risk at that point in time. Now, I couldn't plead that somebody said—
But your argument writes out the next thing that happened in reality, which is that Ms. Frost met with the student. Mm-hmm. It may be that if she had not met with him, your argument would have greater heft. But she took the next step, which is the step that would allow her to determine whether he had stated plans or intentions to commit suicide. And then she did not inform the parents. We don't know, maybe you do, but we don't, and we shouldn't, what happened in that meeting. But we do know that afterward, she did not inform the parents.
Right.
So how do the allegations in your complaint put it within the narrow window that when creates?
I'm suggesting that when creates a narrow window for the graduate student, graduate school situation, and it specifically says that the duty that is going to be drawn depends on the relationship of the schools. I'm suggesting that this court on this issue is writing on a blank slate guided by when, relative to what should happen here. And at the motion to dismiss phase, you're right, you probably shouldn't know what the evidence has developed to be in connection with that, given where we're at in the case. But I think the inference needs to be taken in favor of the plaintiff in this case under the applicable standard of review.
What is the inference in favor of the plaintiff from the factual allegations in the complaint?
She did nothing.
Well, I'm not sure that's just an inference. I mean, I think that's there, right?
It is.
But you are actually asking us to infer that she inappropriately did nothing.
But there's allegations in the complaint to that effect that she deviated from all sorts of standards and obligations, Your Honor. That's in the complaint as well.
Let's assume for the moment that in the meeting, the young man had said, I'm actually fine. My girlfriend is very worried about me. She is wonderful. She cares deeply about me, but she misunderstands what's going on. I did poorly on my science test yesterday. It's made me very upset. I absolutely have no thoughts or plans of killing myself. Please don't worry about me. Would that change your argument at all?
One, that's not what we're dealing with. Two, would it change my argument? Probably not, because when you're dealing with a report from a reporter like this young woman who came in with the information she had and where it's documented, you err on the side of caution. You talk to the parents so they can be aware of what's happening with their kid and can get that child to help. That's the rule. That should be the rule in connection with these cases, because that's how we're going to save lives with these cases.
I do see that your time has expired, but I want to check and make sure the panel has no further questions. We will take the rest of your argument on your brief, counsel. Thank you very much. Mr. Davis.
Thank you, Your Honors, and good morning. John Davis, may it please the Court, on behalf of the Acton-Boxborough Regional School District. I'd like to follow up on some of the questions the Court was asking my brother counsel. With respect to the Wen case, I mean, the starting point is the discussion of a special relationship, identifying that the university had a special relationship with the student. And certainly the cases that the Wen court and other courts have talk about typically a custodial relationship. I think there is a difference.
It means so many different things. I think my question was more about the boarding nature of a high school being more in line with sort of the special relationship that the SJC described in the MIT case versus here, a public high school that the kids are going home at night.
Right, and I think that the phrase special relationship is somewhat fluid in the case law, and it typically goes to what is the scope of the duty. If there is a special relationship, what duties arise out of the nature of that relationship? My brother has cited the Restatement of Torts 3rd, Section 40, and the Section 40 does say that an actor in a special relationship with another can owe the duty of a reasonable care with regard to risks that arise within the scope of the relationship. And it does list a school with its students. And if you also look down at the comments, again, we're talking about something that's in the nature of custodial. In the comment L that talks about duty of schools, as with other duties imposed by this section, it is only applicable to risks that occur while the student is at school or otherwise engaged in school activities. I mean, with the undisputed facts in this case are that 6 weeks pass between the date this young man meets with Martha Frost, and there's no evidence there are no allegations about what took place during the meeting with Martha Frost. And then it's during the summer vacation that this young man takes his life, and that's
That actually is a question I have. Is there any significance to the fact that this tragic event occurred during summer break versus during the school year?
I think there is, Your Honor, because Do
you have any cases here or throughout the country that make that distinction?
Well, I don't know if there's a particular case that makes that distinction. I've cited the McCarthy case. Right. And the McCarthy case, I think, is the closest one, and that was the young man who was in police custody in the city of Waltham. And that young man was released from custody, and 1 hour later commits suicide in his own home. I think, that case, obviously, it's not relying so much upon the duty issue in the Wen case. They don't interpret the Wen case, but that's a case where the court said there's immunity there. Section 10J applies, and none of the exceptions were available to the family in the McCarthy case. And then the other fact is that it takes place at his parents' home. It's not on school property, and it's not during a school activity. So to suggest that the duty arises in those circumstances is a real stretch, and it's certainly not supported by the restatement cited by my brother. And then, Your Honor, you raised the issue about the special relationship. If there is a special relationship, and the Wen case said in the context of a university and a student there is one, there's a limited duty. The limited duty arises if there's actual knowledge, and the actual knowledge has to be of a recent attempt to commit suicide or an expressed plan or ideation or plan or intent by the student. Number one, in this case, there's no allegations that this young man had ever attempted to commit suicide before. And there's, secondly, no allegations that Martha Frost had actual knowledge of any prior attempt, because there's no allegations of a prior attempt. So you don't get that, and there's no allegations that he had a plan on May 30th when he met with Martha Frost to commit suicide, and there's no allegations that she had actual knowledge of a plan. So
is this the appropriate time to make those decisions? I mean, it's a motion to dismiss, and it's so early in the whole stage of proceedings. So in other words, shouldn't it be that the plaintiff has an opportunity to develop through depositions and interrogatories, et cetera, exactly what was said in that meeting, exactly whether anyone had any knowledge of any prior attempts, et cetera, or a plan? This is at the very early stage as a matter of law.
Understood, Your Honor. I mean, but the question of duty is an issue of law. So that's why I think it was appropriate to raise it, based upon the undisputed facts that are alleged, and based upon the facts that are not alleged. That's why I think it was appropriate to raise it. But as you know, the court below did not get to that issue, and in fact, the court addresses it in a footnote. And the court does make the references, the distinction between non-clinicians and professional personnel, but the court doesn't address it because it wasn't raised below. It wasn't briefed before, so that it really is not an issue before this court, because it was not an argument raised before the Superior Court about the distinction between non-clinicians and professional staff. But
what about, though, the suggestion that Brother Counsel makes in his brief that because there had been an unfortunate number of suicides at this school, they were on a heightened awareness, somehow connecting that with the special duty. This wasn't a one done.
Yeah, I appreciate, and my brother makes the point that there's a national crisis, and this is a crisis that not only within school systems in Massachusetts, but a national crisis.
And without question, I think we would all agree. But here you had what seems to be a higher number in a shorter period of time that serve as the backdrop for this young man.
I guess, Your Honor, you could say that perhaps that goes to the special relationship. Perhaps that goes to the scope of the duty that would arise in the context of a special relationship. But it doesn't get to the immunity issue, which is the one the judge relied upon below. I mean, Section 10J says that if you can't base a claim upon the failure to act to prevent or diminish the harmful consequences of a condition or situation that you didn't originally cause. And again, I relied upon the McCarthy case, but here the condition or situation was his state of mind six weeks later.
Can you take us through the three exceptions that your brother cites and tell us why they don't apply here?
Yes, Your Honor. The first, I guess there's four, because he first says that you could base this upon originally caused. And so because I view that as an exception to 10J within the language itself, and the court points out that, number one, the allegations are not affirmative acts. They do say that she met with him, But in order to be an original cause, there's a two-pronged test. It has to be an affirmative act. It can't be a failure to act. It can't be an omission. And the thrust of the plaintiff's case is, after Martha Frost met with him, they don't really criticize what happened because there were no allegations about what happened between Martha Frost and the student during that meeting. But after she met with him, she should have done something. She failed to do something.
Why isn't assuring the girlfriend, I got this, an affirmative act?
If that is an affirmative act, Your Honor, it was an assurance made to somebody who was not a family member. The 10J1 has to do with explicit and specific assurances of safety, and that's one way somebody can can say that 10J does not apply. We were given assurances of safety, but 10J1, specific to that situation, says that the assurances have to be given to the actual victim, or the assurances have to be given to a family member of the victim, and she's not a family member. So that negates the opportunity to apply 10J1. But again, back to original cause, if there is an affirmative act, and basically based upon the allegations presented and pled, there was no affirmative act, but even if there was one, it has to materially contribute to the harm that ensued. And in the cases that we have cited in our materials, here, whatever she didn't materially create the condition of situation by whatever she did. She met with him, and she may have failed to tell people, but she did not materially contribute to creating his state of mind 6 weeks later. And that's why the original cause doesn't work. I explained why 10J1 doesn't apply, Your Honor. 10J2 has to do with an intervention. Here they say the intervention was her meeting with him. She met with him, and that's undisputed. The claim is not based upon her intervention, though. So it's not, 10J2 doesn't apply because, again, 10J2 an intervention has to be an affirmative act, and second of all, the claim is not based upon the intervention, and third, if you intervene to trigger 10J2, the intervention has to put the victim in a worse position, has to cause the harm or put the victim in a worse position than he was in before the intervention. And finally, Your Honor, they seek to rely upon 10J4. And 10J4, that's the one where if the claim is by or on behalf of a patient for negligent medical or other therapeutic treatment, then 10J may not apply. And in this particular case, they allege a social worker-patient relationship without facts. And in fact, social workers meet with clients, they don't meet with patients. And I think words are very, very important when you're interpreting 10J4. And second of all, there's no evidence of what she did when she met with him. There's no allegations of what she did when she met with him. Because with respect to that exception, it has to be based upon treatment, and social workers do a lot of other things, including an assessment, as my brother was talking about. She didn't make an assessment, but they do a lot of other things in terms of diagnose, assess, evaluate, counsel, other than treatment. And also, there's no facts alleged that the treatment that she provided was medical or therapeutic.
But to get back to Justice Walsh's question about timing, how could there be such an allegation at the complaint stage? There are two people who know what happened in that room. One of them is gone, and the other is your defendant. So without discovery, how could the allegations ever rise to the necessary level about what happened in that room?
The plaintiff, they made the allegations that she had a relationship with him, but I would focus again on the language of 10J4, which talks about patients. He's not a patient. Social workers have clients. Social workers don't have patients. I cited in my materials the regulation that talks about social workers and the services they provide. They provide their services to clients, not to patients. So I would say that even if there were facts that were not yet discovered or discoverable, 10J4 can't apply in the context of a social worker. So I've argued with respect to when, if there are no further questions with respect to when or the 10J immunity, I'll rest on my brief.
Seeing none, we will take the rest of the arguments on your brief. This is a very sad and tragic case, and I promise that it'll get our full attention. It will now be deemed submitted, so thank you, counsel, both very much. So this will conclude this morning's session, although I'm told we have a number of students who I think are going to stick around for a few minutes. As council gets packed up, Mr. Quinlan, nice to see you again. I will say that to the students, we cannot talk about any of the cases that you heard this morning. I'm not sure how many you were in here for, but if you would like to actually come into the bar enclosure so we can hear you a little bit better, that would be great.